Hello everyone. So this is going to be a lecture on the historical evolution of English law, and depends how far I get, but ideally by the end you'll know what the purposes of law are, and to know a bit about English legal history and how common law developed through the centuries, as well as to understand the character and role of equity, particularly as it pertains to common law. It's a very complex matter, but we can just scratch the surface to begin with, and then to understand the consequences of the Judicature Acts, which are passed in the 19th century. So first of all, law is never static. It is forever changing. It's a living organism, so it's always forward-looking. And this is not just something that legal historians look into. So the law we have today is a product of centuries of development. So we need to know what the law is now and how it arrived at this state. We're not going to dig into history excessively deeply, because that might tickle some of the people's intellectual fancy, but most of you want to press on and do well in the course and not be overburdened with excessive detail. So if you lived somewhere all on your own, then you wouldn't need laws, because we wouldn't need to regulate the behavior of other people. You wouldn't be interacting with others. But a body of law exists to regulate conduct between people. Otherwise, life can become unbearable. But the laws have to be enforceable, and these laws should reflect popular will. But not allow a bullying majority to mistreat a minority. So there's a delicate balance to be struck. And you'll see how law aligns with politics and history in some wise. Anyway, so there are many roles that law plays in our society, supposedly to ensure public peace, to keep us reasonably safe without being too much of an anti-state, and to regulate how we interact with other individuals, or indeed how an individual interacts with an organization, or the intercourse between different organizations, how it upholds our human rights, how it guarantees our liberties. These are all the ideals. As you may see, the outcome isn't always idyllic. To allow the economy to function smoothly, to allow us to conduct political activity, and so forth, and to manage societal change. So anyway, prior to 1066, there was the Anglo-Saxon legal system, and then there was the normal legal system, which lasted till roughly 1485. Henry VII came in, and he introduced his Tudor legal system, and this imposed over local systems. There was supposedly an excessive degree of localism, and that lasted until about 1832, and equity developed greatly during that epoch. And then after that, after 1832, we're in the modern system, and over the past 200 years or so, common law and equity have fused. There has been a huge development in statute law. I remember Lord Bingham saying there's legislative hyperactivity, he might have said, in continents. So the government has intervened more and more in everyday life. Many administrative bodies have been established, some of them with a quasi-judicial role, and obviously in 1973, the United Kingdom was ceded to the European Economic Community, which eventually morphed into the European Union, and it had its own legal traditions, mostly Roman law, and then that added to the corpus of English law. As I think it was Lord Denning, a celebrated judge, said, it's like an incoming tide. Don't say it will be trivial, it'll have massive effects. Could be good, could be bad, might be indifferent, but it will have a major influence on English law, and indeed it did. Now we're already in the Brexit era, might be removing some of those European laws. They didn't throw it all out, not throw out the baby with the bathwater, so all those laws from the European Union remain on the statute book unless they're specifically repealed, as often happens when a country becomes independent. Anyway, so go back to 1066. The Romans were here until the 5th century AD, and then the Romans left. So there was no England as such. The word England didn't even exist. What is now England was split into many different kingdoms, near constantly at war with each other. Then the Anglo-Saxons came out just as the Romans were leaving. The Anglo-Saxons had their own legal customs, But these were varied a lot from one locality to the next. They were often oral, so when you know centuries later what they were. The country was divided into shires, which we now call counties. There were hundreds. A hundred is an area where roughly 100 families live, and there was a hundredman who was in charge of them, and the hundredman had to be able to both read and write, which most people couldn't, and 100 would hold a moot, as in a meeting, to discuss local issues, but and also functioned as a law court. So some kings, for instance, King Alfred, he essayed to establish a national judicial system, but not very successfully. But the hundreds, they were often called wapentakes in northern England. I'm not sure why. So each shire had different laws, but they influenced each other just a little bit. So what happens when a man dies without having made a will, to say he's intestate? In Kent, there was gavel-kind inheritance, which means the inheritance was split equally between all his sons, and women had very few rights in those days, but not in the rest of the kingdom. Anyway, 1066, William, the Duke of Normandy, he conquers England, having bested Harold II, who indeed was killed at the Battle of Hastings. So the Normans, they changed the legal system a little bit. They didn't do all in one fell swoop. That would be too much. They did it incrementally. Anyway, so it was more of a powerful centralized state was set up. So they made sure there were regularly meeting shire courts. The 100 courts, they continued. And the Normans wanted to centralize administration, which they eventually did. No longer was England several warring kingdoms, but it was a feudal kingdom that was united. So the king's courts were set up, and this was to dispense justice throughout the realm, to try and standardize things. So the king exercised high justice. In a sense, he could function as a judge too. So he only cared about really major cases, especially which impacted on him, his property. So there was the Curia Regis, as in the King's Council, but Curia could also be translated court. And you could only go there if you're a real notable. Anyway, so the king's jurisdiction was not extensive, and it had to interact with courts at a shire level, county courts as we call them now. And there wasn't a clear distinction between criminal and civil justice as there is today. So the king was assisted in the administration of the legal system by some clerics. They really were priests and monks, because they were among the only people who could read and write. And they travelled around with him on his royal progress, touring around, helping him to dispense justice. They were clerks. They were writing things down, looking things up in the law books. Now, eventually, the clerics started doing this on their own, and the king resiled from his judicial role. So they established themselves at Westminster, as in beside Parliament, beside Westminster Abbey, just a few miles away from the city of London, because London was the area around St Paul's Cathedral, only a mile around there. And so the King's Court was set up, and indeed Magna Carta in 1215, that's one of the things it says, there'll be the King's Court at Westminster. So the King's council or court developed into different branches, civil and criminal, as we'll see over time. Then go on to when there were the three courts. First of all, there was the Court of Exchequer, dealing with financial matters. Then there was the Court of Common Pleas, which handled land disputes. And remember, land was a vital economic resource, because 9 out of 10 people were farmers. Nobody cared about oil. Even coal wasn't important. There were no factories. It was land, our most basic need. It's producing enough food to survive, and so that's why you needed land. But that also applied to real property, i.e. houses. So then the Court of the King's Bench was set up, which dealt with grave criminal matters, not petty ones. So these courts stayed that way until the Judicature Acts of 1873. So then look at assizes. And this was to allow for the administration of justice outside of London. So royal justices, as in judges, were sent around the realm with a royal commission, as in his permission, a document from him, to hold assizes, which is a sitting of the court. And so these were itinerant judges travelling from place to place. and the assize courts only handled criminous matters, not civil ones, but later they started to handle civil cases as well. The assize courts continued until the Courts Act of 1971 abolished them. So there were other courts, the Court of the Exchequer Chamber, for instance, and it was an appellate court, as in it dealt with appeals. But those courts were done away with in 1875. We now have the Court of Appeal to dispense that function. So then look at common law. So the king's courts were vital to resolving disputes between citizens. The law at that time depended upon the customs of the country, things which were justified by past practice. That's why I say common law. And this was especially so in relation to the first assizes that Henry II set up. He thought that civil disputes were just overly lengthy. He wasn't going to have such dilatory courts, and that's why things had really broken down under his predecessor. So he wanted the king's courts to function all across the nation. So this new system grew up, and it was very much dependent upon the king's courts, and they established their supremacy over local courts, which were on a shire by shire basis. So as the king's courts expanded this scope, many of the baronial class perceived this as a threat to their dominance of their locality, because they had a lot of say in the courts. But the new system continued to develop. Anyway, it was eventually firmly established and universally recognized that they were supreme over the courts in each county. That was by the reign of Edward I, who took over in, oh my goodness, I should know this, in 1270. Anyway, it's worth noting that there are several different meanings of common law, which is very confusing. So common law can be used in the historical meaning, as in to mean the law which is applied by the king's judges and not just local customs, as I say, because each county was doing things a bit different. Or indeed, common law could mean the law which was applied by the king's courts and not the rules of equity, an equity which developed in the Court of Chancery. There was a time you go to the king's court if you want to be handled according to common law, you go to the Court of Chancery if you wished it to be handled according to equity. We could use common law to mean we're talking about case law. So based on what various judges have decided down the centuries, and they can change things. There's precedent. There's this principle of stare decisis, stand with the decision, to follow that precedent, but just occasionally the judges say, this is a seminal moment. We need to throw out that precedent. New situations developed. So it always evolves. But following precedent is different from following statute. Remember, a statute is a law passed by Parliament or any other legislature like the Welsh Assembly. So common law could also mean law in the United Kingdom or other Commonwealth countries, as opposed to Roman law. And Roman law is what you find on the continent, or indeed countries which are erstwhile colonies of France, Spain, and so on, because they inherited the Roman law traditions of those nations. So let's now turn our minds to the writ system. This type of common law was developed by the king's courts and to do with procedure. There wasn't an automatic right of getting a hearing at a king's court until 1875, the Judicature Acts. So if you wished to lodge a claim there, the claimant had to buy a writ from the Chancellor. The Chancellor was the head of the king's writing department. He was always a clergyman. And so once you got that writ, then you could bring your case before the court. So the price could be prohibitively expensive. So the writ was this document, and it had a wax seal with the king's Great Seal of England. And so that required the defendant to present himself before the court for the hearing. And it would say what the basis of the claim was, your complaint. You felt you suffered injustice at the hands of another. This is known as forms of action, this complaint. So the writ system became overly hidebound, and the writs became fixed, so only Parliament could permit another writ to be issued. And if so it was on this basis that you claim that person had done whatever it was wrong, but in our precedent we can't find someone having committed an action like this or a claim being made like that. So as your situation is unprecedented, no writ will be issued. So that's why. So then the court said, well, we're not going to allow that. We're going to intervene. We're going to try anyway, even though no similar situation is ever recorded. People felt that the rules of procedure had become overly ossified. Having to fit inside a form that had already existed, had to stick too rigidly to precedent, and so it stifled the development of English law. So these are the early form of actions. That's to say, writs. So a real action in the court of common law was quite often to get back land which another had wrongly taken from you. So these are called a writ of right. And so the king often commanded a feudal lord to try a case about who had the legal title to land, especially as freehold land in the feudal lord's area. So the action could be resolved in trial by battle, as in really was taking up swords and seeing who dies, believing that God would favour the innocent party, and that would sort it out. So it was nothing to do with strength, with hand-eye coordination. Anyway, the king eventually got complete control over the writ of right. Henry II set up the Grand Assize late in the 12th century, and this allowed the defendant the option of submitting to trial before 12 knights instead of trial by battle, because Henry II thought this ridiculous. There's nothing to do with justice, just who happens to be mightier. So Henry II, he also developed the notion that a jury trial should go ahead with the creation of a possessory jury or a petty jury, as it was, petty assizes or possessory assizes, petty meaning small. So the assizes, they didn't issue any declaration of an absolute title, but instead they tried these cases by looking at who seemed to have a better claim to own the land. Actual possession also tended to help, hence the saying, possession is 9/10 of the law. Notably, the development in this area has done a lot to colour how we understand land law, or the law of property more generally, because the law of property is not just land. Some of the same principles are applicable to intellectual property, for instance, and that's quite different to civil law systems. Title of land here is relative. It is not absolute. And in the strictest legal theory, if you own land, you only have an interest in it because the crown owns it. So let's look at some personal actions now. A personal action is when you're seeking a remedy which is damages, i.e. money, to pay you back for the wrong which has been done to you. A sithment, we used to say, because you would get assez, as in enough in French. You would get enough money. Might be on a quantum meruit basis, as in Latin for as much as he deserves. Like quantum of solace, like enough solace. All right, so debt. Supposing someone was in debt and they had to pay you back. So you would pursue an action for whatever the stated amount of money was, and in return you get an executed consideration, which means a signed document underpaying to pay you back more, or there could be détenu. This is a claim for a particular movable item. It could be furniture, could be horses, could be jewelry, could be cash, which was wrongfully kept by another party. So this is there was to be an option of damages in lieu, as in have to pay you money instead of giving that horse back or that item of furniture. So it's about chattels. Chattels are movable property. So chattels are not land, not houses. Chattel sounds very like cattle. I wonder if that's part of the etymology of it, because cattle is a good example of it. Anyway, so debt and détenu were triable by wager of law. That means the people who testified, as in swore, before the court swore an oath about the defendant, saying he is of good character, he's trustworthy, and therefore the claim is just not credible, because no, this person wouldn't wrongly keep another's goods, this person wouldn't wrongfully fail to pay a debt back, because I know him, he's a man of the uttermost probity. Anyway, So there was another thing, covenant. This is a legal action when you are seeking damages, i.e. money and compensation, arising from someone breaking his promise under seal. That's by deed. So a deed is a particular legal document and often be sealed with wax. So get some wax, melt it onto the document, and then get your seal, which would have a particular symbol on it, this piece of metal, and then stamp it into the hot wax, and the seal would be there in the hot wax for all to see. Everyone could see it. It'd be very detailed, so you couldn't fake it to make it an official document. So like a signature, especially in a time when most people couldn't write. So very important to keep your seal, your piece of metal, with the actual pattern there on your person. Nobody could steal it and then forge documents, making it look like you'd agreed to things when you hadn't agreed to them. Anyway, so in this covenant action, consideration wasn't necessary. Perhaps I'll tell you what consideration is another time. So the idea of a covenant is that the promise is put into a deed. It's not just an oral promise. It's not just promise in the casual sense. It's a legally binding promise. And that is still important in law down to this day. Then there's another thing called account, and that is usually considered to be procedural. It's not a substantive remedy. So that is used to force somebody to account to the claimant, that's the person lodging the claim, for the money that he received from the claimant. For instance, a bailiff who was paid rent on behalf of the claimant, not directly by the claimant, on behalf of the claimant. So where did that money go? What did you do with it? Or there are other sorts of cases they used to deal with. Trespass. Now, we all know about trespass as in walking onto another person's land. That's usually a civil wrong. Now, under certain statutes, if it's like a royal domain, that can be a crime, or certain army barracks, that can be a crime, not a civil wrong. But generally speaking, it is a civil wrong, and the police don't want to get involved. But trespassers will be prosecuted. You might remember from Winnie the Pooh. But trespass can be trespass to the person, as in touching your body in a way that you don't want. Now, this is not meant to be criminal, it's not meant to be rape or something. Or trespass to someone's goods, so taking them without the intention of permanently taking them, because that would be stealing. Just borrowing them without permission, that's trespass. So trespass is not just about damaging something. It can be indirectly caused. It could be against some physical goods, or it could be harming your reputation. But later on, this developed into an area of tort called defamation. So trespass was being seen as a grave matter, and not just a civil wrong in those days. And you could be charged with this crime even if the defendant the claimant couldn't prove that a loss arose therefrom, as in you borrowed my horse, then gave it back or something, but that didn't cause me any financial loss. I didn't need the horse that day. The horse is still in good health, but nevertheless, it's actionable per se. Per se is like on its own, without you the claimant having suffered any loss. It was still a bad thing, and you can still take action against them. So you'd be put on trial before a jury. That's to say, it was an indictable offence, and for the most part, this was in the court of the King's Bench. Anyway, case. This was a legal action which allowed for a remedy when no remedy seemed to exist in the law. In the modern law of tort being wrong in French, tort, this was for things like nuisance, malicious falsehood, as in lying about somebody, or breaking a contract, libel, that's publishing a lie about someone to ruin the person's good name, slander, that's saying it out loud but not in a recorded format, as in a lie that damages someone's name, or deceit, as in lying, but it has to be an important lie, even if it doesn't damage someone's reputation, or negligence, so failing to perform your duty. There are also writs and procedures. Now, these were types of actions, and the writ system gave an example of how the common law system became excessively rigid due to the unduly complex and onerous procedures. For every single writ, there was a particular procedure. This had to be followed to the letter, stage by stage. So if you picked the wrong writ, or you didn't follow the procedure precisely, the action was finished. And the trouble was that common law didn't seem to think enough about an individual's rights and duties. Instead, it was just fixated with procedure. Why was this? So common law was set up as a way of handling these issues when the writ system was failing. The courts therefore developed as part of this central system directed by the king, and the objective was to resolve these disputes and rather than to provide justice. It wasn't a system initially that was about right and wrong. It seemed to be too procedural. Now, one of the other bugbears with common law is that in personal actions, it usually said we can have damages, i.e. you can be paid money and compensation. So if somebody broke a covenant, as in like a contract really, the person who'd been wronged couldn't demand what we now call specific performance, as in actually requiring the person to do what he was contracted to do. So let's look at how it developed from 1485 onwards. Equity came to the fore because of the difficulties in common law, which I adumbrated a bit earlier. The litigants, as in those who were taking the legal action, who thought that justice was not provided in the king's courts, would write a petition and send it to His Majesty, asking him to do justice in this case. So the monarch, who swore in his coronation oath that he would do equal and right justice, and in discretion and mercy and truth, he was meant to be the fountain of justice. So the Lord Chancellor, he was usually a priest, and the king's confessor, keeper of the king's conscience, was meant to deal with these matters. And remember, the Chancellor was in charge of the writing system. That's what a chancery is. Like it's a chancery building in Berlin, for instance, or there's even that font on the computer, chancery. So there are obviously hundreds of clerks under him because he deals with all the documents coming to the king, like court records, tax records, or letters from other monarchs. So in the 13th century, the petitions were then handled by the Court of Chancery, and Chancery law exists to this day. The Lord Chancellor was the head of all that. So sometimes he was also the same person as the Archbishop of Canterbury. So equity is the set of principles and rules which are administered by the Court of Chancery, or at least they were until 1875. Again, it's our favourite, the Judicature Acts. Now, so let's look at what equity is. The Lord Chancellor had to be able to go beyond these excessively rigid rules of procedure which had grown up in common law, and he wanted to be able to handle the cases based on what seemed to be a natural idea of justice. So there was a moral aspect to all this. So the Chancellor, remember, he was always a Catholic priest, and his religious education had led him to know about canon law, as that's the law of the Catholic Church, and indeed Roman law, because it was the Roman Catholic Church. He's very much in touch with the continent. So at first he decided these claims according to what seemed just to him, and he didn't look back to precedent. So one legal scholar, Selden, said that equity, well, that's really just the Chancellor's conscience. It could vary from one Chancellor to another. But so if you want to know how much a foot was, measure the Chancellor's foot. And the thing is, it might just, how do we know that he's someone who's got such a great conscience? He could just be capricious, or could just like you or dislike you. So certain principles of equity were developed, and especially written down in the 17th and 18th century. They're known as equitable maxims, and the Court of Chancery looked to these. So we all say equality is equity. Equity looks to substance, not form. That's probably the crucial one. Equity looks to substance, not form, and that's the big difference from the earlier system. He who comes to equity must come with cleaner hands. If you come to equity, you must not sleep on your rights, as in you must take prompt action. If you tarry too long, no. Anyway, so writs and documents were required in common law courts, but they weren't used in these courts of chancery. Claims in equity couldn't be thrown out about something that was de minimis, of the very smallest, such as like a name was misspelt in a document or something. So the chancellors, they had legal training over time, and they eventually said, yes, we've got to look to precedent, stare decisis, as I said. The common law counterparts appear to be fixated with at that time. So equitable precedents eventually evolved. The system was then added to with certain bits of common law. Equity is like the gloss on common law. So equity is not a different and competing legal system anymore. So let's look at how equity started to recognize rights. There's the use or trust. So when landholders went overseas to fight, particularly in the Crusades, they needed somebody to manage their land for them, but particularly to collect rents as well as to discharge their feudal duties. So this custom developed whereby the landowner could transfer his title to someone else, but he had to repose complete trust in this person, but the land was to be used for the benefit of the landowner. There were some cases where the person he put in charge ripped him off and wouldn't keep to whatever agreements had been made, take the money for himself, and not give the landowner's wife and children any money. So the common law courts had to resolve this situation. It was intolerable. So they recognized the rights of the original landowner, or indeed his heirs and successors. The common law courts hadn't recognized this and said that you've got no locus standi, as in you've got no place to stand. You can't appear before this court. There's no case to answer. But anyway, the Chancellor said, well, this is unacceptable, and said, based on equity, it goes against conscience to allow the person who's been put in charge of the estate to abuse this trust that's been put in him. So the recipient, as in the person who's been trusted to look after the land, he must use the land to benefit the one who actually owns it. And if that person dies, to benefit his family. And so this helped bring us to the law of trust, which we'll go into much later, okay, about, a trustor, a trustee, beneficiaries, and so forth. So let's look at the equity of redemption. In common law, if somebody was meant to pay something and the deadline had passed, the right to claim land that had been conveyed as security was gone. So if you don't pay me this money, I'm allowed to take some of your land. So equity said, no, that rule is excessively strict. So equity allowed a approach of greater flexibility, which permitted someone to redeem the pledge for repayment even after the due date had passed. So that is vital in relation to mortgages to this day. So let's look at some equitable remedies. As I said earlier, the only remedy that the common law permitted was damages. So the Court of Chancery came along and said there are some difficulties in this common law process. So we're going to add some more remedies. An injunction. This is an order by the court obliging people to do something, or indeed preventing them from doing something. We have super injunctions about the media to this day, because certain footballers like to go dogging. I'm not naming names, but the media can't say who it is. Or indeed specific performance, saying you must do what you were contracted to do, okay? Or a rescission. This is where the court puts the parties back to where they were before the contract had been signed. Or indeed there's rectification. So the court rectifies an agreement that isn't right, and that makes the agreement be as it should be. So if you make a claim in equity, you don't have the right to claim equitable remedies. These are up to the Court of Chancery. These were up to the Court of Chancery. For example, if the claimant did not come to equity with clean hands, they say he wouldn't be able to get anything out of the Court of Equity. Right, I think we've gone on long enough. So let's leave it for there, about halfway through what I want to do on this subject. Toodaloo.